Thank you for attending the February 2nd or February 3rd IIPS meeting. We will discuss 3 important facts, 5 myths, and 10 potential pitfalls to remember in connection with the Unified Patent Court and quote-unquote UPC land that Martin has just trademarked. I'm going to let Martin introduce himself since he's a recurring and prized presenter to the IIPS. Some housekeeping items. I will put in the chat the forms that you need to download and email back to me in order to get your CLE certificate. At the end of the presentation, I will also give you the code which you need to apply to the forms before you send them back to me. I'm also going to be taking screenshots of the participant list at various times throughout the meeting, so don't disappear. And I will also distribute the presentation by PDF at the end. I'll slip it in the chat. If you don't get it for some reason, feel free to email me. And we don't have anything on the horizon, like you see with UPC Land, but our aim is to do something every month, a month and a half, like we used to. Anyway, Martin, take it away.
Okay. Yeah. I mean, I would jump right into it. Actually, I have so much to talk about when it comes to UPC, because this is a project that is on the agenda for more than 50 years. I remember when I became a patent attorney candidate in 1993, 30 years ago. It was already there, this unitary patent idea. And now, only 50 years after they started, there's this unitary patent package at reach, I must say, because it's not yet in force. It's delayed and delayed and delayed and delayed, and you know the jokes that are made about these people. Currently, there's another postponement because we still do not have our chip cards that we need in order to make the positions and to log in. I'm even not yet admitted to practice before the UPC because without that chip card, I cannot register myself. And so many others also cannot register themselves. Anyway, we have now the unitary patent and the unified patent court. And this thing is so good that it comes close to a no-brainer. And I will explain to you today why this is so. As a user of the unified patent court and the unitary patent, I would say it all boils down to one decision that you make, our clients must make. Do they invest into litigation-grade patents or not? If they do, then the UPC and unitary patent is a must because it comes with so many advantages. If you go for economy class patents, bulk drafting and so, then it still may make sense to not opt out of this, because for 7 years you can opt out of that and pretend that it's not there. And it may make sense if you have only those economy class style patent applications, if not very many of them, then the UPC also can make sense. But anyway, I've coined the term UPC Land because I think it's the better approach to look at it as a new country that is created, and that coincides with what we have to tick in the grant forms of the European Patent Office. There's a UP box, and if you want a unitary patent, then you have to tick that box, and that comes with a few other consequences. The system is now set to start on 1st of June, and there's a sunrise period currently that is to start on the 1st of March, but more about that a bit later. Now about myself. I'm a Singapore patent attorney, a German patent attorney, and a European patent attorney, and I'm in the patent business since 1993, so 30 years this year. I'm an expert for patenting computer algorithms, and when I say computer algorithms, then yes, I'm writing successful patent applications where you can patent the algorithms. And there are a few decisions out there that went up to the Enlarged Board of Appeal and also to some higher courts. So this is something for those who go very deep into computer patents. I'm also a gearbox aficionado. That comes with my earlier training. I'm a trained motorbike mechanic from very young, so I'm a craftsman as well. And I'm also a founder of a law firm, Schweiger and Partners. We have offices in Singapore, of course, then in Munich, of course, and I'm currently turning that into a legal tech company. We are focusing very much on AI patent drafting. So I'm also organizing a convention, an annual convention is the Computer Patent Drafting Symposium, and I'm issuing a white book currently. But this is more about teaching. Today I heard from Harris, so please just overhear my pitching here. I'm also an editor of a IP blog, the iplawyertools.com blog. You would see a few websites there. So what I do is I put all my contents that have to do with law and patent law and with opinion away from our professional website, so that there's a distance to that. Because what I say is my personal opinion, and not necessarily the opinion of my partners in that firm. Good, so let's start. You surely know that from the reports about the ongoing war in the Ukraine, which is here, the white country bordering Russia. So these are the 44 countries where you can get a European patent. And there's also a country up here, Cambodia, that is not in Europe. And also 2 countries here, Tunisia and Morocco. They are also not in Europe, but in Africa. Cambodia is in East Asia, I would say. Yeah, it's the best what you say. But you can get a European patent in these countries here. 39 member states, 1 extension state, and 4 validation states is a bit procedural here. Then we call the patents that come out from that system bundle patents, because you need to validate them expressly in the countries where you want them. Opposed to that is the unitary patent, where you have a single validation at the EPO with unitary effect, and it will cover many but not all of the states that you have seen here. And in order to better show the difference between the European patent and the unitary patent is blue. While the European patent, the colors remain here. So you can see where you have a unitary patent. But that's just a nice overview. So we are now done with a geography lesson. What is important is there's one single court, the Unified Patent Court, for all those, for the blue UPC land. I call it UPC land. The EP covers about a market of about 700 million people, while UPC land has 295 million inhabitants. Well, it's quite massive. It's not much smaller than the US with 330 or 350 million, or how many you have there. Now, let's talk about economics here. 50% of the world's GDP is made by these 5 countries here: US, China, Japan, Germany, and India. 50%. And that's, if you know the Pareto 80-20 principle, that's the third order of the Pareto 80-20. 80% of 80% of 80% is roughly 50%. And then 20% of 20% of 20% is 4%. So these are the 4% of the countries that do 50% of the world's revenue. Then you have 1/3 about for that group here: Russia, France, Canada, UK, and Italy. Then it's a bit more speckled here. Netherlands I can see here. And then the rest of the world is practically neglectable. So what I tell people always when they decide where to file patents is look at the economic power, and then you look at how far do you go with your budget. And that's the main limitation for them. Now, let's look at the figures here. The GDP in trillion US dollars is US 21.4, massive. China 14.3, UPC land 13.4, right? And then you have Japan and Germany, which is also here in the UPC land, and India. So the UPC land has roughly the economic power of China, with the number of people that live in the US. And the I think that's massive. So this is to be taken seriously. And the UPC land in the world is the only country that still grows, because as you see before, there are still states that have ratified. I'll show you later that they have ratified the UPC, but they have not yet put it in practice. But it will come. UPC Land States maps. So you have the countries here who decided to be part of UPC land. And these are the dark blue ones here. And then you have the lighter blue ones, Cyprus, Czech Republic, Greece, Hungary, Ireland, Romania, and Slovakia. They are very soon going to be part of the UPC land. While the others, Croatia, Poland, and Spain, still have some problems with the translations, and they may only follow later. But the growth potential already sits there. But again, this can work in both ways, as you know. The UK was also a part of UPC land and decided to leave, I believe for good reasons, because the common law system is so much incompatible with the civil law system that we have in the UPC land, that it's really questionable whether a common law country could join such a much bigger construction. I don't think so. Anyway, you can have up to 3 parallel patents in one and the same UPC land country for an identical subject matter. I'll give you an example for Germany. You have a national DE patent, then you have the bundle EPDE patent, or alternatively the unitary patent, and then you have the utility model. Is called the little patent, and to be taken very seriously, because the definition of the prior art for the utility model is much different from the national DE patent and very much in favor of protection of the utility model. In order to obtain a unitary patent, a UP, you file a conventional patent application for a European patent, and you don't need any separate or different application. The decision of whether or not you want to designate UPC land will be made at the time of grant of a European patent. And at that time you decide what you want. Do you want a pure bundle patent collection, or do you want unitary patent? And no, you cannot add EU countries to your unitary patent if these EU countries ratify after your unitary patent is granted. So whenever one of those lighter blue color countries join UPC land, you still will be left with a national patent, the bundle patent, whatever is there. The sunrise period starts on 1st of March. This is when you can opt out individually or in bulk the European patents of your choice, because you need to know European patents, even if they're not unitary patents, would fall under the jurisdiction of UPC land per default. And you can say for a grace period of 7 years whether or not you want that. Right? And we talk about that. What is already possible since 1st of January, you can request a delay in issuing the publication of the mention of a grant of a European patent. That gives you time to get a unitary patent. So if you have a grant from now on until 1st of June, you can tell EPO, please delay grant, and so that I can get a unitary patent. You can also request an early unitary effect that has to do with the damages. Damages calculation is for some more advantageous under the unitary patent, and even before grant there are some claims for damages, and you can already arm your European patent application to fall under the new definitions of the unitary patent and the UPC patent court. Now let's look at the locations of the UPC, the Unified Patent Court, and as you can thing already, there's not one single court building. There are several courts. There are, in the first place, the central division in Paris and Munich. And then there are local divisions, and the local divisions are all over UPC land. And then there are also regional divisions, mainly in the northern countries like Finland and Sweden, Estonia, Lithuania, and you look it up. It's not so important. What is important for you is that the central division is in Paris. So whenever you get patent litigation, please choose the Paris court, because Paris is such a nice city. It's always worth going there, even if you have only one afternoon. And this is the best, I would say. Maybe also Milan, Milano, and also Munich, my hometown, of course. English language proceedings are available almost everywhere. I mean, of course, you have Europe. Nobody nobody in the EU speaks English anymore except for Ireland. And despite that, English is the common language in Europe. And so I think this is important for you, because then you don't need translations. So you can always make it happen that a court proceeding is held in English language. And you also get what is important. You get technically trained judges of German, Swiss, Dutch, and Nordic origin. And that would give you some extra quality in the decision themselves. So that is important and worth mentioning. Then there's the selection of the court venue. You have either the place of infringement or the central division. The central division is always in the game when we talk about revocation. Revocations are always done centrally. Then the important thing is, and this is really what makes the UPC so powerful, you get an intermediate or preliminary injunction immediately, even without the defendant being heard. That's a very German way of enforcing patents, and I know it mainly from the trademark side, and it is a very sharp sword. And Germany is known internationally for that option. And also the decisions of the German judges are very clear. So if you translate them into English, even by using Google Translate or DeepL, there would be something that can be understood in all other countries. I've seen that several times in Asia. And then, of course, these judges would apply the same reasonings. And the UPC decisions can be swiftly asserted in the entire UPC land. And that is very different from now in the EU. If you want to enforce decisions of a court in the EU, this is so much difficult that is not fun. Even a lawsuit, let's say, about a European patent that has been validated in Germany, and then the patent owner is in Finland, just serving the initial action, the initial complaint on the defendant in Finland is a major effort that would cost you $10,000 or $15,000 and would take 3 or 4 weeks or so. Not so in the Unified Patent Court. In the Unified Patent Court, this is done within days and no translation needed, no certification, no whatever. It's done in no time. It's so much better. Then the UPC provides a mixed common law and continental law style litigation, combining the infringement and invalidity but avoiding lengthy trial days in court. I know from my own experience, because I'm litigating both in Germany under civil law and in France under civil law, and also in Singapore. And in Singapore, I for the first time I saw the common law system, and I like it so much, because when you can combine the invalidity and the litigation into the same proceedings, then the same judge would interpret the patent claims in the same way. And it's not that one judge in invalidity interprets them in this way and the other one in litigation, in infringement interprets them in another way. And very often it's not matching and gives weird outcomes, very often. And I like this concept that the founders of the UPC have combined the best of both worlds and also avoided lengthy trial days in court. And this is what I do not like in the common law system, that even for minor issues, there's one afternoon spent and every party wants to have a say about this or that, and then there would be cross-examination about whether or not a certain letter had been served on something, and we spend an afternoon about finding out who is the true inventor of something. And then we end up in court cases that are 4 days, 5 days, or even 2 weeks long. No wonder that this is expensive. The UPC cases are usually done in one only day, in one single day, with one single hearing, and then you get your decision in the first instance. You have bifurcation in the US, and I found this book here quite interesting to read. And there's also a Netlist case. There's a company that was a supplier to Google, the Google search engines, and Netlist had some technology for speeding up such searches. And then Google, at one point in time, being much bigger, they decided to develop their own technology. And then Netlist sued them out of a patent portfolio of 70 or 80 cases. And Google started to defend themselves with USPTO proceedings for re-examination, I believe. But among others, on my website, you find a whole article about the Netlist story. And of course, After 10 years, nothing is left of netlist while Google is still existing and they are still using their own thing and not the netlist devices. The same in China. China also has a bifurcated patent system, but they are now aiming at holding joint infringement and validity hearings. So they also recognize that there's a problem with this bifurcation. So I like this very much in the UPC, and this gives us a clear advantage for the UPC over the US and the Chinese cases. Let's talk about the main advantage of the UPC is that you have unified material case law, and it starts already with novelty. Did you know that there are some countries in Europe, in the EU, for which the novelty is not only a photographic novelty, but also equivalents are seen as novelty destroying? Now combine that with a jurisdiction of the European Patent Office, which has a photographic novelty, and that will be unified, and you will know how it will be applied. So there are no longer these funny situations where this falls apart. Then inventiveness, right? And inventiveness, under European points of view, always is only available for elements that come with a technical advantage. So if your patent application doesn't mention an advantage or technical effect or both for a certain element, then you cannot limit your claim by taking up that element from the description or from a subclaim or so, and then argue in favor of inventiveness if that argument or that advantage that is not taken up into the patent application. This is a major difference between the drafting style in the US and the drafting style and the litigation style in Germany. Or in UPC land, better. I heard that if you take up an advantage into a patent application, in a US-style patent application, then a device that has all the elements of the claim but not that advantage would not be seen as infringing. And that's simply, from a UPC point of view, simply nonsense. The claim would determine the scope of protection, but you can only argue in favor of inventiveness if you have the advantage or the technical effect of specific elements taken up in the description at the time of filing. You cannot add them at a later time. Then equivalence is handled the same all over the UPC land. The current standpoint is equivalence is decided upon by a view at the time of the earliest priority date of that specific combination of elements that you are arguing. So the question is, would the person skilled in the art have a reason to read a certain element of the claim only in a narrow way, or can it take up in a broader way? It depends on what the person skilled in the art knew at the time of the earliest priority date. Then the priority is also unified. Some countries allow to draw priorities for claim elements that were not clearly disclosed in the earliest priority document, and others do not. And now this will be unified. Then added subject matter, of course, will be unified. Then lack of enablement. In other words, can you make it with what is described in the patent application? As opposed to sufficiency of disclosure, does it work at all? While the lack of enablement cannot be healed by later submissions, that's the current point of view of the European Patent Office and also that of the Unified Patent Court. You cannot take up elements into the patent application if you have a lack of enablement, because then you simply did not file what was necessary. But if the disclosure is not sufficient, it means, does it work at all? So, for example, you claim a certain drug composition, and it is not clear whether or not this drug is really efficient for a certain illness or disease, then you can furnish documents at a later time. At least currently this is so. And the good thing is this will be seen the same all over UPC land and different from today. It could be with the current situation that you will be successful in Germany, but not so in Italy, and maybe not in Spain, but also in France. And this is unified. And also selection invention, that is also something new for you, because the US law doesn't know selection invention. I explain in very short words what I mean. It is very clear that copper is novel over metal. I hope that you all agree. If not, then please write me something in the chat that's interesting. So if the prior art document says metal and my invention is copper, then the element copper makes my invention novel over the prior art that shows only metal as a general term. But how about this? You have a mixture of three components A, B, C here in a certain percentage together given, and then this is a tertiary diagram. So you have this point M for the mixture in this tertiary member. Is this mixture novel over the general knowledge that you can mix the three components A, B, and C? I hope that you all agree that this is novel, but where do you draw the borderline between an invention and not? And there's this theory of determining whether the scope of protection is allowable or not falls into the heading selection inventions. And all what is here is selected from the broader range of all three. And that would give you a whole range of values for certain parameters that determine your invention. And the selection inventions must be very carefully supported by measurement data, or at least must be sufficiently disclosed on what basis you have determined all these selections. And if that is the case, then you may be able to get a patent for such a selected range. What you cannot adjust at a later time are the values for determining whether or not is the scope of protection that you want. Usually you have nested loops of areas from big to very small, and you need for each one of the borders of the loops, you need to determine at the time of filing what you're claiming. So you cannot file the ABC and then at a later time determine what scope of protection you would select from that. Good to know for the UPC how are damages calculated. The injured party must be put into the same position that it would have been in if no infringement had taken place. Infringers should not benefit from the infringement, but damages shall not be punitive. And when I read this is in clear against what we know from the US with the treble damages for willful infringement. So there's no such thing in the UPC system. The Continental Law, which is not UPC law, says three options. You have first a license analogy, means that you determine the damages according to a license agreement that is reasonable. A second option would be the restitution of profits that the patentee lost, or a third one, surrender of profits made by the infringer. And that one is very attractive because you can get an accountant, look into the books, the accounting system of the infringer. They would determine the revenues that have been made. The revenues, you can deduct the costs that come with the infringing product, and then you have the profits, and then these profits have to be surrendered to the patent owner. The good thing is that only those costs can be applied that are directly related to the production of the infringing product, but no overhead costs, and that's quite severe. So this is, I would say, the most often applied case in Germany currently. But that is gone because the UPC calculation of damages does not have that. Another thing that is good to know, expert evidence. Same as in the common law system, the UPC system has the option to provide expert evidence if they consider it necessary. And that would be a real piece of evidence. And different from continental law, expert witnesses are selected by the court only. You can still file an expert opinion by each party, but these are not considered formal evidence. This is an opinion only. So the judge is not bound by that, while if the judge selects an expert witness, then the statement of this expert witness in the continental law would become evidence, formal evidence. And that has been liberated for the parties, and that is a good element that has been taken from the common law system, because it can take months or years until the court can select a witness to whom both parties agree. In German law, that's something really that delays court proceedings. As I said before, prepare for litigate-grade patents. When you have a US-style patent and you want a UPC litigate-grade unitary patent, you must obey the European patent standard. The independent claims should come in a two-part form. You should use multi-dependencies, or you can multi-dependencies in the dependent claims without having extra claim fees. You must provide a support section for the claims. For each claim, you have to provide definition, advantages, and technical effects. And for the reasons I stated before, this is necessary and makes it the original US style claims are usually kept, or you can keep them in the specification so that they can later be used again if wanted. Sometimes you need that, especially when you file a PCT application, you want to have both claim sets inside. Although I recommend that you stop filing a PCT application together with other countries and then nationalize from PCT into the US. Because by doing so, you import all the file wrapper estoppels potentially from overseas into the US litigation. Also, if you file a PCT application that complies with the EP requirements, then you have all the definition, advantages, and technical effects that you do not want to have in US litigation. So I believe that the US patent law and the non-US patent law is not compatible to a sufficient degree that you can use a PCT application for both at the same time. You should also provide consistent reference numerals throughout the specification. I recommend also in the claims. And even if different terms are used in the claims, they can both have the same reference numerals as the terms, the corresponding terms in the description. And also there should be a reference numerals list. Important. Also, you should provide formal support for so-called intermediate generalizations. That's also a very new concept from the European Patent Office. If you want to limit yourself over a new piece of prior art, you cannot just arbitrarily take up any elements from or features from the description of the embodiments. They must come together as they are meant in the description of the embodiment. So you cannot simply say, if you have an embodiment that comes with 15 or 20 features or elements, you cannot simply arbitrarily take 2 or 3 of them and not take the other 17. The EP examiners will force you to probably include the entire embodiment into that if you're not good in arguing. And so what we do is we create fallback positions in advance when we draft the patent application, and we say these 3 claim elements belong together technically, and that's our fallback position that provides a technical effect and that advantage. And only then can you only selectively these 3 claim elements take up into a patent claim. Of course, you should provide an updated prior art section with an appropriately worded object of the invention that avoids all elements from the invention. By the way, this is what we learn in the European Patent Agent Qualification exam until it comes out your ears. So for us that sounds normal, and for you that must sound very weird, I think. Same as for us, that you can get a patent without having an advantage in it. So it's simply a very different system. This is my recommendation. At the end of the priority year, you must do a conversion of US style to UP-EP style and file in parallel a US patent application and a PCT application in order to avoid adverse consequences from the EP adaptation to the scope of protection of a later granted US patent. I would suggest that you let an EP attorney do that conversion for you, and we're only talking about the conversion, not more, because you will still file the PCT application for your clients and represent them before WIPO. So you would you're used to work with EP patent attorneys because they would handle also your EP applications. But it is a good choice to let your EP attorney also help you to convert the US style to UP-EP style. That not only provides a smooth grant and a broad scope of protection in the UPC land, but also in other procedures like European Patent Office, as for the EP patent, DE, UK, China, Japan, and also Singapore, just to name a few. Australia comes to my mind, South Africa. So all these would benefit a lot from having the EP features of a patent application. We have specialized on that, and there are 2 days turnaround time sprint services for these available. You just need to look a bit or ask your favorite European patent attorney. In very short words, there's an opt-out possible. And please do me a favor and forget about it. It's only expensive and it will get you nowhere. So as a default, all EP patents would fall under the jurisdiction of the Unified Patent Court, all of them. But for a period of 7 years, you can opt out. And that is pretending that the UPC is not there. But as you now know, with all these advantages, I believe UPC is a no-brainer. But although all big players in the UPC land industry will not opt out, and I've asked them, the pharmaceutical industry will opt out. Because for the pharmaceutical industry, having patents in place and not getting them revoked because of prior art or other reasons has an extra value. So if you have one unitary patent, then you are open to central attacks on that. And within one only court action, this thing will be away. But I understood that for the pharmaceutical industry, it's important to have some patent protection somehow. So all those pharmaceutical guys, they would still go for the old system, at least for some time. You should know that if you opt out from the UPC system, that does not automatically make UPC lawsuits inadmissible. So even if you have opted out, someone can sue you at a unified patent court, and if you do not respond within 1 month and bring up that this is not admissible, then the UPC will take up the case and just deal with it as a normal case, and you will not be heard. And as a foreigner, you need to know, you need to have a representative before the UPC. You cannot do it yourself. And I believe not even the patent owners themselves can opt out. They need to engage a UPC representative for doing so. What goes without saying, please don't show up with a crappy patent at the Unified Patent Court unless it is in bulk. Something like in suing an infringer with an economy class style patent will only work if you have 3 or 4 or more of them. And I've seen that working, but one single crappy patent should not be there. Then I have a way, I've written an article so that every one of you, even without asking me, you have a recipe on how to get a unitary patent or a European patent within 1 year of entering the regional phase at EPO. You find that article on my personal blog. The personal blog is IP Lawyer Tools, and here is the address. You will get the slides here so they can look at iplawyertools.com and then course EPO acceleration. That gives you all the steps that you need to undertake in order to get the track 1 European patent. You can do it yourself. You don't need me. And this is not common knowledge. I would say that 99% of all European patent attorneys are not able to do that. But if you know the recipe and you can look it up on my blog, then you can also do it, because it's not magic, it's not witchcraft. And of course, there's a EPO Track 1 sprint service for this available as well. Areas that will very soon get clarification in the UPC unitary patent area. Can you have a European patent, a bundle patent, and a unitary patent for identical subject matters in one and the same country? Currently, I would rather say no, but I do not see any reason why the 2 patents should not be there at the same time. The EP, European patent, as a bundle patent and opted out from the jurisdiction of UPC, and the unitary patent being per default, or you cannot opt out a unitary patent from the jurisdiction of the UPC. So that having the 2 in parallel would make sense. Next question is, can a non-UPC land country allow their national patents to be litigated in the UPC? And can the UPC decision later be enforced in that non-UPC land country? And I'm already thinking about one already, and you may know, I will come to it on the next page. The question is, I would say yes, why not? The UPC is a normal court, and why should a country not allow, a country like, I don't know, Cambodia, why should Cambodia not allow to have a patent? Because Cambodia is one of those countries where you get a European patent, right? So why should Cambodia not allow a European patent, a bundle patent for Cambodia, to be litigated in the central division of the Unified Patent Court? And why should then Cambodia not allow that decision to be enforced in Cambodia? I don't see any reason why not. Next question is, what happens if a UPC land country leaves the EU? Yeah, we had one, the UK, but same as for the European trademarks, you ended up with a EU trademark plus a national trademark for the UK. This is what will happen. Is the UK in the UPC? No, it's not. The UPC is only open to participation by EU member states. And in addition, these member states need to ratify the Unified Patent Court Agreement. The UK was an EU member state and ratified the UP Patent Court Agreement in 2018. However, at the time of leaving the EU in 2020, Brexit, the UK also withdrew its UPCA ratification. Fun fact, the Article 7, Paragraph 2 UPCA still defines London as a section of the UPC's central division without being there. And the UK, I heard several times, so why not having a unified patent court in London? London is quite a nice city, right? So makes sense. And no, this has been removed, and now very likely Milano in Italy will get the central division's share of the UK. Question is, can the UK rejoin the unified patent court? I would say yes. UK rejoins the EU. Now you ask yourself, how likely is that? I would say is 99.99999 unlikely. And then UK ratifies the UPC agreement one more time. And then they would be automatically in. Now, yes, despite the UK not being part of UPC Land, the UK EP patent attorneys can plead before the unified patent court. And also, the same, the Turkey EP patent attorneys, like Turkey. Please note, since last year, you do not write the country name Turkey like the bird that you have for Thanksgiving. This is the new writing. This is the politically correct one. So please note that. Turkey is a bird that you can eat, while Turkey is the country in Europe. So, not only the Turkish, the UK, all European patent attorneys that have an additional legal qualification can represent before the Unified Patent Court, even if their own home country is not part of UPC Land. Next one. The language does also not make a difference. Nobody's mother tongue in UPC Land is English, maybe only Ireland, but Ireland is not a UPC country yet. All the judges in the Unified Patent Court, they speak an unceremonious English like I do, and nobody in Europe likes legalese. So, as a UK patent attorney pleading before the Unified Patent Court, I don't really see the big advantage. It may be better if you come with an Italian accent. And as we are talking about the UK, the UPC Land gives you 5 times the bang, namely GDP, for only half of the litigation costs in the UK. If that is not an advantage, then what? I wanted to highlight this to you. If you want to know what European means in intellectual property, I've written an article here, Perfect Confusion, what European means, and this is the URL where you find that article. I would recommend that you read it. It would only take you 10 minutes, and I promise that it will make you laugh, because this is so confusing. Nobody in Europe has the same definition of European. For me, for example, Turkey is Europe. If you ask Germans, 80% of the Germans would tell you, no, Turkey is Asia. But if you ask the Asians, and I'm just back from the Asian Championship in powerlifting, and that was in Dubai, they consider Dubai as Asia, while they say, or even Jordania says, yeah, Jordania is Asia. But Turkey, no, Turkey is not Asia. Turkey is in Europe. And my article would highlight a few things. I will very soon publish an updated one once the UPC is in force. And then I would also take the new acronyms and terms that have to do with Europe into the same article and republish it. If you sign up here, then I will send you an email with updates of that article. Please go there now, do me a favor, and sign up for my newsletter. And we are now done with my talk, and we can go 10 minutes questions and answers.
We have one question in the chat, I think. What happens if you say you also want coverage in Poland or Spain and they do not ultimately join the UPC? What would you do?
File a European patent application, prosecute it to grant, then tick the UP box, and then tick the boxes for Poland and what was the other country? Slovakia or whatever.
Yeah.
Yeah, it's very straightforward. By ticking UP, all the UPC Land countries will be automatically selected that are there at the time of the grant. And for all the others, you tick the countries that you wish.
Any other questions?
Yeah, I have a couple of other questions. Sorry to monopolize. One question is you were mentioning with respect to injunctions.
Yes.
What is the criteria for granting an injunction with the UPC then?
What is the criteria?
Yeah.
Okay. It's twofold. First, you must prove that you have a claim, and the claim is the infringement. So you must prove the infringement, but you don't need to present the full evidence. You can, for the interim injunctions, there are lower standards. You can prove the infringement with a statement under oath, for example.
Oh, interesting.
Very powerful.
Yeah,
I tell you, this is so powerful. This is incredible. And the second thing that you need to show is that there's a reason for that, a reason for the injunction. And the reason being there cannot be too much time since you have first noticed the infringement until you request the injunction. 1 month is already too long. There is no official deadline, but what I can tell you is 4 weeks is okay, but 1 month is too long.
Interesting. I also have another just real quick question with respect to, when the European Patent Court gets going, will they be relying on, the as far as precedent goes, looking at previous decisions from the, European Patent Office, Board of Technical Appeals and that type of thing?
Partly, yes. The problem being that the European Patent Office only issues decisions that are important with respect to material law, as I mentioned before, novelty, inventive step, but not about scope of protection and about infringement. So that comes from the case law of the UPC countries. And now guess the most important patent litigation country in UPC land is Germany. And also the presiding judges are from Germany. So there's my guess is that they would apply German infringement case law.
Even from the beginning?
Yes.
Okay.
Don't forget, in Germany, there are hundreds of patent infringements per year, if not thousands. In the UK, we talk about dozens. And the only two very serious patent infringement jurisdictions in Europe is Germany and the UK. Maybe Netherlands. But that's already it. And not France.
Why?
I did litigation in France, and seriously, is not something that I really want to have.
Okay.
The decisions.
I'll take your word for it.
You don't. Yeah. It's my personal opinion. Yeah. It doesn't mean that. What I like is UK style infringement. It's a bit long and expensive, but it's okay. Good.
Any other questions?
I'm not sure you answered the question. Maybe I wasn't paying attention. There was another question in the chat about whether, you said 4 weeks is okay, but a month is too long. Was that from the infringement or from the start of the infringement? I mean, from discovery of the infringement. I'm not sure if you answered that.
Discovery comes with a special meaning that a bunch of lawyers would go through your emails. Once you have noticed that there is an infringement, that time period starts to count.
Like actual knowledge.
Yes. And that should be supported by a statement under oath.